Welcome back to Lighthouse Health and Safety Podcast. This is episode 4, an overview of work health and safety legislation in Australia. My name is Andrew Chandran. Today's agenda is going to cover the hierarchy of workplace health and safety legislation, a specific look at the Work Health and Safety Act 2020, which is part of the harmonised suite of legislation in this country. We're then going to look at a very important legal term, which is reasonably practicable. And I'm going to explain what reasonably practicable means. I'm then going to show you a method that I use to demonstrate whether you have reduced risks so far as is reasonably practicable. Because these are the words that are used in the Workplace Health and Safety Act. And finally, I'm going to have a small segment which encourages us to focus on the laws of tomorrow. And I'm going to give you a case example of why we need to take that to heart. So on to the hierarchy of workplace health and safety legislation. And for the purpose of this episode, I'm going to limit that to acts, regulations, codes of practice, and guidance notes. The Act is something I like to refer to as closest to God. Now, I don't mean any disrespect by that comment. It's just how I think of the Act and how I like to explain it to other people. The Act is the formal, broad description of the law. It sets out the setting of key principles, duties, obligations, and the rights of various duty holders in relation to work, health, and safety matters. It includes the power to create regulations, and it also includes the power to approve codes of practice, which I'll come to later. Regulations are created by the Act. Regulations support the Act but provide more detailed information about the duties in relation to particular hazards, procedures, and WHS obligations. From a day-to-day perspective, when it comes to managing and controlling hazards and risks at a workplace, you'll find that the regulations will be a more pragmatic type of document that you would refer to rather than the Act, which sets very, very high duties. And now we come to codes of practice and approved codes of practice. These documents provide guidance to duty holders to help them meet their duty of care obligations. Ordinary codes of practice are not legally binding. They have really the weight of a guidance note, which I'll come to next, but they are admissible in courts as evidence. However, an approved code of practice is legally binding. And if duty holders choose not to follow a code of practice, then they will need to put in place an alternative to meet the same intent. And that alternative must also be reasonably practicable to implement. But if a duty holder chooses not to comply with an approved code of practice, then we got a problem. That is a direct contravention of the legislation. And finally, we come to guidance notes. As the name implies, these documents provide guidance on how duty holders may comply with the requirements of the Act or regulations. Generally speaking, guidance notes contribute to the overall knowledge of hazards, risks, and controls, so duty holders can understand what is reasonable to do and can choose options that best suit their circumstances. However, if guidance notes contain technologically sensitive material, for example, where standards may change over time, then that guidance note may be obsolete, and a duty holder would need to inform themselves of current guidance, or what we call good industry practice. And now we come to the Work Health and Safety Act 2020. Look, there are lots and lots of health and safety legislation around the country, in various industries, and for particular types of hazards as well. So the idea is not to cover them all, but what I'm going to do is I'm going to give you a very brief and useful overview of what the general duties are that a duty holder must comply with, regardless of what piece of legislation you are operating under. Now, under the Work Health and Safety Act, they've dispensed with terms duty of employer, duty of employee. Instead, you have a new term, a person conducting a business or undertaking, which is a PCBU. That term, PCBU, can include body corporates, so companies, unincorporated bodies or associations, partnerships or sole traders or self-employed people. So it's a very broad definition, and as we go into the legislation, I'll show you how it differs from the traditional duty of an employer who traditionally had obligations to their employees and no others. Well, the PCBU has a much broader obligation. So a PCBU has a primary duty to ensure the health and safety of workers while they're at work in the business or undertaking, and others who may be affected by the carrying out of such work, such as visitors. The Act also has a definition around an officer of the PCBU, which is an individual in an executive or senior management position who has significant control or influence over a workplace and its decision making. Right, so let's break it down even further. We have a particular section of the Act called Section 19, which is the primary duty of care of a PCBU. The good thing is it's actually the same section that was in the previous legislation, which is Section of 19, Duties of Employers, except this time it's a PCBU. And this primary duty of care is as follows. A PCBU must ensure, so far as is reasonably practicable, the health and safety of workers engaged or caused to be engaged by the person, and workers whose activities in carrying out work are influenced or directed by the person. So in a traditional employer-employee relationship, the relationship is very, very clear. But in this case, you could have an employer engaging a contractor who has its own employees, and that contractor could be engaging subcontractors who have their own employees. A PCBU has accountability for all of those people whilst they are at work in the business or undertaking, which is interesting because they just simply have to be there and satisfy that requirement. They don't even need to be actively engaged in work. And secondly, to this primary duty of care, a PCBU must ensure, again, so far as is reasonably practicable, that's that SFAIRP acronym I introduced you to previously. They must ensure that the health and safety of other persons is not put at risk from work carried out as part of the conduct of the business or undertaking. So in the first clause, the person just needs to be at work in the business or undertaking. In the second clause, they need to be put at risk from work that is carried out as part of the business or undertaking before an offence might be incurred. Moving on. The Work Health and Safety Act offers one tremendous advantage, or in my view, at least one tremendous advantage over the previous legislation. It has a very, very special clause called Clause 18. What is reasonably practicable? And it actually provides somewhat of a definition of the components that make up that term. This is very, very helpful. Reasonably practicable in relation to a duty to ensure health and safety means that which is or was at a particular time reasonably able to be done in relation to ensuring health and safety, taking into account and weighing up all relevant matters, including, and this is where it gets very, very interesting, it must consider the likelihood of a hazard or risk occurring, the degree of harm that might result from the hazard or the risk, what the person concerned knows or ought reasonably to know about the hazard or the risk, and ways of eliminating or minimizing the risk, the availability and suitability of ways to eliminate or minimize the risk. And finally, after assessing the extent of the risk and the available ways to eliminate or minimize the risk, the cost associated with available ways of eliminating or minimizing the risk, including whether the cost is grossly disproportionate to the risk. Now, this is a very good clause that's been introduced because it gives you some insight as to how you can demonstrate that you've reduced risks so far as is reasonably practicable and generally satisfy the intent of the legislation. The term reasonably practicable actually goes back to a decision that was made in Edwards versus the Coal Board in 1949, where Lord Asquith presided over the matter and actually deemed that the term reasonably practicable must incorporate a computation of the magnitude of the risk versus the ways of actually reducing that risk. We might call that costs, the costs associated with reducing the risk. And that computation of cost and benefit would need to be taken into account to demonstrate whether you had got to that point. The same thing applies here, but in modern language. So let's break down these elements. The likelihood, right, of a risk occurring, you would typically do that in a risk assessment. The degree of harm of a risk occurring, again, you do that in a risk assessment. We would often term degree of harm as severity. It's the same thing. The third item was what a person knows or reasonably ought to know about a risk or hazard and ways of eliminating it or reducing it. I'm quite curious as the wording here. It talks about eliminating or minimizing a risk. I probably would have changed that to eliminating the hazard or the person, right? Because if you eliminate the hazard or a person, you're going to eliminate risk. Or instead of saying minimizing risk, I think they should have said reducing the risk would have been more appropriate. Because the objective of the legislation is not to minimize the risk, it is to reduce the risk so far as is reasonably practicable. So this is why I think that term minimizing is a bit misleading. That should be reducing the risk. All right, so this step here is an interesting one because it means that if you are going to be sitting in a risk assessment, you would need to have people in the room who know, or reasonably ought to know, how to eliminate the hazard itself, or perhaps the person. That would achieve the same goal. Or if you couldn't do that, ways of reducing the exposure to a person, right? And that's why I like to use that term exposure. It's an easier term to understand than risk, especially when you're explaining to people who are at risk. You know, for example, if I go to a worker in the field and say, hey mate, your risk of being struck on the head is high. He's just going to look at me and go, okay, I've got no idea what that means, but that doesn't sound good. Or I could go to him and say, look, the thing that could fall here is not particularly heavy, but we've got half a dozen of these falling every day, so the chance that one might hit you is pretty significant. Oh, okay, right, we need to reduce the chance that that's going to happen, right? Absolutely, you've got to reduce the chance it's going to happen. Now we're talking. And so this is why I like to use the term exposure, because effectively exposure is a mathematical equation. Once you understand the equation, you just reduce the parameters and you reduce risk. So just moving on again, within this term, what is reasonably practicable, you need to consider the availability and suitable ways of eliminating or minimizing the risk. I'm just reading the language verbatim as it is, even though I think the wording needs to change. Now, to do this, you would need to be familiar with what's going on in the industry, right? We often refer to that as good industry practice. What are my options? If you don't know what your options are, then you're not really going to be satisfying this requirement. I have very, very rarely seen in a risk assessment workshop one where people actually consider the suitable and available controls. They will often come up with a control which has worked before, and so they'll put that in there. If it gets to a point where they need to demonstrate that they've done the risk assessment, satisfied what is reasonably practicable, they're going to struggle. Right? And that's often why organizations would do a SFAIRP demonstration, or ALAP. ALAP is very similar to SFAIRP. It's often why they would do one of those demonstrations after the risk assessment process to actually satisfy themselves that they have taken all reasonably practicable steps to reduce risk. And now you're getting a bit of an idea as to the value of guidance material in the form of codes of practice and guidance notes. They are there, publicly available, to inform people on what can be done or what could be done, but they are not exhaustive. And then you're looking at a cost-benefit analysis at some point where you're actually weighing up the benefit you're getting from the controls that you're looking at, that benefit being the reduction in risk that you're getting. It's the risk reduction benefit versus the costs to implement those controls. Now, cost is not simply monetary cost. You need to look at a situation. You need to look at all the potential costs involved in introducing a control. You could be introducing something that's novel, unproven, untested, right? Not very reliable. We don't know how it's going to go. It could impact the schedule, right? Which could be a really big issue. Budget is not really a big deal. Budget itself should not be a reason why you discount a particular control, right? You should not be doing that on financial reason alone, just because you haven't budgeted for it. You may consider whether the control introduces other problems. So, for example, I was working on a site and they had a policy, blanket policy across the whole site, that everyone needed to wear foam-backed safety glasses, even when you were driving a vehicle. Okay, and what I noticed when I was driving a vehicle on site is because the foam and the back of the glasses caused the glasses to sit forward on my face, it impacted my peripheral vision. Now let's take this in context, right? Foam back glasses, why? Because people were getting dust in the eyes. Okay, great. However, reducing your peripheral vision while you're driving, surface mobile equipment incidents are some of the worst we have in the mining industry, for example. Is that an appropriate trade-off? I would suggest not. And there are other things as well that you need to consider with any control. What is the impact of this control on the operation of, say, plant that people are working with, that people have to maintain, right? So there are lots of different things that need to be considered when you consider the cost to implement a control, not just the risk reduction benefit you're expecting to get. So those parameters and understanding those parameters will give you a good understanding of how to demonstrate whether you've reduced risk so far as is reasonably practicable. And now, just to finish off this episode, I wanted to finish with an important case study which really was quite influential with myself as a young work health and safety student, actually, at the time. And even to this day, it sends a very, very powerful message. And this is the case study about the H.W. Johns Manville Company. So if you haven't heard of H.W. Johns Manville, I'm not surprised. They're a very, very old company. They were founded in 1858 as H.W. Johns Manufacturing Company. They merged with Manville Covering Company in 1901. They produced insulation and construction products containing asbestos for commercial, industrial, and residential buildings. In 1982, they filed for bankruptcy following thousands of people developing asbestos-related disease in the 1970s and 80s in relation to exposure to the asbestos contained in their products. In 1988, they emerged from bankruptcy and established the Manville Personal Injury Settlement Trust in the amount of US $2.5 billion. Back then, that was a lot of money. In 2001, they were acquired by Berkshire Hathaway. And since 1988, the settlement trust has grown from $2.5 billion to over $5 billion US dollars. When the former CEO, Thomas Stevens, exited the business in 1993, he was quoted as saying, "The real challenge is to get companies focused on tomorrow's laws rather than today's. That is the standard to which companies are ultimately accountable." And I really like this quote, and I really like this message, because it shows you that decisions that you make, even 100 years ago, maybe even more, under different legislation, can come back and haunt you. So as an organization, you need to be strategic, you need to be adaptable, you need to be ensuring yourself that risks are indeed as low as reasonably practicable to minimize your liabilities now and in the future. So the next time you're on LinkedIn and some armchair lawyer there is talking to you about, well, the Work Health and Safety Act requires this and it requires that, just remember, we are actually accountable to the laws of tomorrow, whether we know it or not. And that's it for today. So be well, be safe, and see you later.